Hi, everyone. Harry here to talk about the hot off the presses judicial opinion by a judge in Manhattan denying the government's motion to unseal grand jury materials related to Ghislaine Maxwell. The headline here, and it's what many people, certainly including me, have surmised from day one, is there's, as to quote the judge, there's no there. The only reason, says the judge, to possibly reveal them to the public would be to expose the government's disingenuousness in trying to suggest there's something big that's responsive to the whole Epstein brouhaha. This has always been a bullshit diversion operation that the government, A, was likely to lose, so they could say, oh, we tried, but our hands are tied. But B, and more importantly, they could suggest this is, here we go, the grand jury information about what happened in the Maxwell case. This is what everyone's looking for. Always a load of crap. The grand jury here in the Maxwell case, remember, convened by Jim Comey's daughter, who's since been fired. First, it was just about the Maxwell case. You read the indictment in Maxwell. It doesn't identify any of the customers, the people who victimized all the underage girls. It simply says that Maxwell and Epstein carried out a scheme to do this and had at least one commercial transaction. That's all they had to show. So if you look at the indictment, you realize that in order to support that indictment, the grand jury didn't need to hear all the evidence that people are now clamoring for. More importantly, Engelmeyer, who's a former federal prosecutor and knows how this stuff works, identifies just what happened here. It's a fairly typical arrangement for big, important cases, because for a lot of technical reasons, when you put somebody in the grand jury and have all their evidence given to the grand jury at trial, you may be forced to turn that over to the defense and give them more tactical advantage to know how to prepare their own response to your charges. That's something that prosecutors try to avoid. So what happened here? For each of Maxwell and Epstein, there was a single day. A grand jury filed in. They took an agent who had investigated the case and just said, well, I then did this, and this person said that, the hearsay part of it. That's why you heard, oh, this is all hearsay in the files. No, the grand jury heard hearsay because it's the safest way for federal prosecutors to get an indictment. They go through for hours, then this, and then they can, even after that agent leaves the room, kind of feel out the grand jury. Offer them the chance to ask questions of the agent, bringing the agent back, and get a sense of, are they over the threshold here, and are they going to get it? And if not, maybe give more from the agent, but nothing about the evidence in the case. Not to mention, it's to prove the case, you didn't have to do any of this kind of uncovering of files that people needed. Okay. He also does Engelmeyer go through process in a way that, to me, points the finger at Bondi, because there's a motion that is filed before where they inform the court, oh, it looks like there's all this other stuff, and the Attorney General is going to request that it be delivered up to her. Okay, let me give you a little bit more on the law. So, grand jury material, secrecy, very much protected and safeguarded. You can really, for one, dirty up people unfairly if they're talked about in the grand jury, and just in general, it's an investigative, typically, not here. Here, the grand jury did not do any investigation. They didn't do subpoenas, anything like that. But you worry about it when a government's investigating. That's not charges, and you don't want to victimize people who may be mentioned, like the underage girls here, or even defendants who haven't been convicted. So the rules passed by Congress say here are the narrow 6 circumstances when you can release grand jury material, and national security, or everyone's dead. There's a few. Same rule in Florida, where this also came up, but in New York there's another little wrinkle that doesn't exist in Florida, namely the Second Circuit has said, and there can be times where maybe you can do some other reasons that are not among the 6. And in particular, the case that the Second Circuit's talking about is if there's really intense historical interest. So the government has come in trying to shoehorn their motion into that exception, but they got nothing. What they've really had to say, when you read carefully, a lot of rhetoric and kind of blather, and then they say there's intense public interest here. Public interest, not the same as historical interest. And if it were, imagine any high-profile case would have an excuse to release grand jury information. That it's exactly those cases where you most want to safeguard it. So it's very much not the law. And so Engelmeyer says, no, we're not in the first 6 in the rule. And then he goes through a 9-stage factoring process that the Second Circuit has said for the special circumstances, and no way here. Okay, so on the law, we don't have any excuse. But then more generally, here's the headline. So the court's review of the grand jury stuff confirmed that unsealing the materials would not reveal new information of any consequence. He actually told the government, tell me what you got. Show me, just to me, privately, what information is not in the record already from the trial. And it seems like it was laughable. They came up with, as he put it, scattered words, clauses, and occasional sentences that are few and far between. The highlighted snippets supply, at most, tertiary details about the same conduct that was public because it was in Maxwell's month-long trial. So, a member of the public familiar with the Maxwell trial record who reviewed the grand jury materials that the government proposes to unseal would thus learn next to nothing new. No person other than Epstein and Maxwell is having had sexual contact with a minor, no identity of any of the clients, insofar as the United States has implied that there's an untapped mine lode of undisclosed information. No way. That's just not what it is. And anyone who reviewed it would find there's nothing new to learn about, and would come away feeling, and this is why he can say the government, all you'd really find out is they've been disingenuous. They would come away feeling disappointed and misled if I expose this. And I thought about doing it for that very reason. There was another case he cites where you can do it just to basically show the government's being disingenuous, but he did not apply that case. But he said, would come away feeling disappointed and misled. There is no there. And so the case is a far cry from any kind of special circumstances. So that's a really, it's pretty sharp upbraiding of the government, basically saying they're disingenuous, but B, it really sets to rest the whole sort of back and forth dispute that's been in the press, etc. It says that this has always been, and again, I'm not patting myself on the back. I'm a prosecutor, and I realized right away how it worked. What you have is stuff that a FBI agent tells the grand jury just enough to do the Maxwell indictment and not everything else. And moreover, you have the revelation that in the last few months, under Bondi's rule, is when all this other stuff was delivered to the department and under her leadership. So it also kind of brings the lie to the efforts in Congress to subpoena Merrick Garland or Loretta Lynch or people who have nothing to do with this. It's all the mother lode is A, not Maxwell, B, under the control and has been of Bondi, and C, you can imagine why she first said we're going to give it all up and then was embarrassed and had to retreat to, oh, there's no list, etc., because presumably, having told Trump, his name's in there quite a bit, the concern was the political concern of having his identity outed, not as a criminal, but as a sort of what many people in the Epstein circles say about him, a good buddy, a wingman, and the like. What he looks like from the videos we've now seen again and again of sort of carousing. So, no, we won't release grand jury materials, but no, there is nothing in there that people are trying to find. Look elsewhere if what you're trying to get is the information about victims and the like. And this little head fake by the department should be at an end. It never had any promise of turning up the information that MAGA and others are insisting on seeing. Talk to you later. Thanks for tuning in. If you enjoyed this video and other Talking Feds content, please take a second to like and subscribe. Talk to you later.